Let's pick up that thread and get some analysis on that judgment with legal analyst Elton Hart. Elton, good morning. Thanks for your time. Really do appreciate it. Legally speaking, how significant is the SCA's dismissal of this deportation challenge, and does it set any precedent for future cross-border arrest matters?
Iman, I would not say it sets precedent, because for me, also the dissenting judgment for me is the more well-reasoned one. Because the thing is, with deportation and extradition, we need to take these two processes away from each other to say there are certain rules and regulations and protocols that needs to be followed in each of the one. In deportation, is a country doesn't want you there, you are an unwanted alien, and they send you back. Where extradition, if you are found because your country, your home country, is looking for you for alleged offenses, then you need to appear first in that court, and there's process that needs to unfold. And I think this is where the niggly point is between the state and the defense at this point in time. And the mere fact that the judge that read out the judgment, he dissented with the majority of the court, and obviously it was written by the DP of the Free State. And for me, the mere fact that there is a disagreement amongst judges means that there is room for the law to be developed, and I see that they can then pursue the avenue so that we get legal certainty on whether a person can really consent to an illegal act. So can I consent to say that I consent that you can actually murder me, and that will exonerate the other party who actually committed the act of murder. So that is, because this will have that type of effect if we say you can consent to an illegality, because it can be used in other courts in different sets of scenarios, because the principle will then be set. And I think the Constitutional Court needs to jump in here.
I really love that concept that you share with us around the law needs to be developed, because it's just a reminder that laws are still, they live in a context, they live in a place, and they can change. It will be interesting to see what happens here. Then very quickly, given what you've just said, it's likely that her legal team then would use this and it would give them legs for the Constitutional Court.
No, indeed so, because Judge Lopia in the High Court judgment, he said sort of how, when his judgment, he said that she consented, but he said that the deportation was a disguised extradition. And now the dissenting judgment also says, like, we agree with what Judge Lopia said. So for me, the judge reading out the judgment and saying that there have been dissent from 4 other judges, it shows to me that here amongst judges even, there is not clarity as to what we need to be following. And I think for us to get that clarity, Constitutional Court should be in. Somehow it's little victories, and the NPA say they will bring everything in their arsenal, but the law is the law. You need to work within that parameters, what's on the record, and they need to just come and argue and say, listen, yeah, do we allow in our law, or legal principles allow that a person can consent to an unlawful act? And that is more, you can bring whatever you bring, but you are bound by the record. So we look forward to what's going to happen with the case going to the Constitutional Court, because I want it to go there so that we have that certainty, and South Africa has certainty as to what happens. But in actual fact, and the bottom line of all is, Iman, and I want to quickly tell this to you, even if Magudumana actually wins in the Constitutional Court, I call it's a futile exercise. Yes, it will be good for law, but it will not be in favor of her case, because the charges where she's charged with aiding and abetting, defeating the ends of justice, and those type of other related charges that comes with the Thabo Bester saga, is not going to disappear. That charges will still remain. It's just that maybe they might release her and later on then ask her on a summons to come back, or they can arrest her again and say, now we're charging you with the following crime. So we need to understand this is an academic exercise. We're going to develop our law, but the charges will remain intact.
Yeah, you've answered the follow-up question I was going to ask, which is how does this affect her ongoing trial? We see that the NPA has welcomed today's ruling, and they want this trial to proceed without any delays. Again, just applying your analytical brain to this one, what hurdles, if any, still exist that could stall or further complicate the trial going ahead? And I think the expectation is July this year.
Now we need to look at Nandipha. She's got her own legal woes and battles that she's fighting. Thabo has his own. And then we must know there's, I think, another 7 other co-accused that also has a say in when the matter will proceed. because all the legal representatives and their clients need to be ready to proceed on the same day. So if they're also going to bring other applications for access to the docket, access to information, or other interlocutory applications, that can all stall the whole process. One can most probably say that I should not be part, and maybe make representations to the NDPP to say why I should not be part of that proceeding. So all those things must first be ironed out, leveled, before we can actually have an idea as to when it will start. And we know that Thabo Bester was also in court with his case of access to a device so that he can actually properly prepare for his trial, so that he type up his pleadings, because he made the argument that pleadings in court must be typed and submitted via case lines and court online. So, which is legitimate things that he raised, but there is also security concerns and they need to balance those things. So there is other accused that also has a bearing on how this trial will proceed and when it will proceed.